Hello future officers, and welcome back to our channel. When we're deep into UPSC prep, certain parts of the Constitution, like fundamental rights or DPSP, get all the attention. But what about those seemingly small, miscellaneous parts? Are they important? Absolutely. Today, we're demystifying one such crucial section. Part 19, titled Miscellaneous. Trust me, by the end of this video, you'll see why skipping this part is a big mistake. So, grab your notebooks, and let's dive right in. Part 19 of the Indian Constitution contains a series of articles from Article 361 to Article 367. The title Miscellaneous might sound like a random collection of leftover provisions, but that's not the case. These articles are essential for the smooth functioning of the government and provide clarity on various procedural and legal matters. Think of it as the constitutional glue that holds different pieces of the governance framework together. It deals with protections for high-ranking officials, defines key terms, and handles interpretation issues. Let's break it down, article by article. First up, Article 361. This is a very important one, especially for prelims and mains. It provides legal immunity to the President of India and the governors of states. What does this mean? It means they are not answerable to any court for the exercise and performance of the powers and duties of their office. So, if the president makes a decision in their official capacity, you can't drag them to court over it. The action of the government can be challenged, but the president or governor personally cannot be held liable. This protection is not absolute, though. Article 361 clarifies a few things. First, their conduct can be reviewed by any court or tribunal appointed by either House of Parliament for the investigation of a charge under Article 61, which deals with the impeachment of the President. Second, while they have immunity for official acts, this doesn't stop anyone from bringing a case against the government of India or the government of a state. You sue the government, not the individual holding the office. Furthermore, Article 361 provides personal immunity from criminal proceedings. No criminal case whatsoever can be started or continued against the president or a governor in any court during their term of office. They cannot be arrested or imprisoned during their term. However, when it comes to civil proceedings, the rules are slightly different. A civil case can be filed against them for acts done in their personal capacity, whether before or after they entered office. But there's a condition. 2 months written notice must be delivered to them, stating the nature of the case, the cause of action, and the details of the plaintiff before the case can be initiated. This ensures that the high office is not frivolously dragged into personal litigation, which could distract them from their constitutional duties. Moving on, we have Article 361A. This article was added later by the 44th Amendment Act of 1978. It is all about the freedom of the press. Article 361A gives protection to the publication of proceedings of Parliament and state legislatures. It states that no person shall be liable to any civil or criminal proceedings in any court for publishing a substantially true report of any proceedings of either House of Parliament or a state legislature. This is a cornerstone of our democracy, ensuring transparency and the public's right to know what their elected representatives are discussing. The key phrase here is substantially true report. This protection doesn't cover malicious or distorted reporting. Also, this immunity doesn't apply to the publication of any secret sittings of the House. Next, we have Article 361B, which was added by the 91st Amendment Act of 2003. This article deals with disqualification for appointment on a remunerative political post. It specifies that a member of a House who has been disqualified on the grounds of defection under the 10th Schedule shall also be disqualified to be appointed to any remunerative political posts for the duration of their disqualification period. This was a crucial reform to curb political horse trading, where defecting legislators were often rewarded with ministerial berths or other lucrative positions. This article strengthens the anti-defection law by closing that loophole. Now, let's look at Article 362. This one is interesting from a historical perspective. It originally dealt with the rights and privileges of the rulers of former Indian princely states. It ensured that their personal rights, privileges, and dignities, as agreed upon in their covenants with the government of India, would be honored. However, This article was repealed by the 26th Amendment Act of 1971, which abolished the privy purses and privileges of these former rulers. So, while you won't find Article 362 in current-day constitutions, it's important to know its history for your modern history and post-independence consolidation topics. Article 363 is next. This article bars interference by courts in disputes arising out of certain treaties and agreements. Specifically, it says that no court has jurisdiction in any dispute arising out of any treaty, agreement, or covenant entered into by the rulers of Indian states with the government of India before the commencement of the Constitution. The final decision on any question regarding the interpretation of such treaties rests with the President of India, and their decision is final. This was a political arrangement to ensure that the integration of princely states, a sensitive process, was not bogged down by legal challenges in courts. Then there is Article 363A, also introduced by the 26th Amendment Act of 1971. This article formally recognized the abolition of the privy purses. It explicitly states that the recognition granted to the rulers of Indian states ceases and privy purses are abolished. This was a landmark step towards establishing a truly egalitarian republic where no special privileges were granted based on birth or lineage. Article 364 deals with the special provisions as two major ports and areas. It empowers the President to direct, by public notification, that any law made by Parliament or a state legislature shall not apply to any major port or aerodrome, or shall apply with certain modifications. This allows for specialized governance and regulation for these critical infrastructure hubs, which have unique security and operational requirements. The President can make such orders to ensure the proper functioning and administration of these vital areas. Article 365 is another powerful provision, often read alongside Article 356, which deals with President's rule. Article 365 states that if a state fails to comply with or to give effect to any directions given by the Union government under the provisions of the Constitution, it shall be lawful for the President to hold that a situation has arisen in which the government of the state cannot be carried on in accordance with the provisions of the Constitution. In simple terms, if a state government willfully defies the constitutional directions of the central government, the President can impose President's rule in that state. This highlights the federal structure with a strong center, a key feature of our polity. Now we come to the last two articles in this part, which are all about definitions and interpretations. Article 366 is the definition clause. It's like a dictionary for the Constitution. It defines numerous terms used throughout the document, such as Anglo-Indian, borough, corporation tax, estate duty, existing, law, federal court, goods, warranty, high court, pension, proclamation of emergency, railway, ruler, scheduled castes, scheduled tribes, and taxation, among others. For UPSC aspirants, going through these definitions is incredibly important. Many prelims questions can be tricky, and understanding the precise constitutional definition of a term can be the key to getting the answer right. For example, the definition of goods and services tax under Article 366(1)(2)(a) is crucial for understanding GST-related questions. Finally, we have Article 367, the Interpretation Clause. This article provides general rules for interpreting the Constitution. It states that the General Clauses Act, 1897, shall apply for the interpretation of the Constitution, just as it applies for the interpretation of an act of the legislature. It also provides specific interpretive rules, for instance, for references to acts or laws of, or made by, Parliament or a state legislature. This article is the toolkit that the judiciary, especially the Supreme Court, uses to interpret the various provisions of the Constitution, ensuring consistency and coherence in constitutional law. It ensures that the Constitution is read as a living, organic whole. So, there you have it. Par 19, miscellaneous, from providing immunity to the President and governors, protecting press freedom, and tackling political defections, to defining key terms and laying down rules for interpretation. These articles are anything but random. They are the nuts and bolts that ensure the machinery of our state runs smoothly, and as intended by the framers of the Constitution. For your exam preparation, remember the key ideas. Article 361 on immunity, 361A on press freedom, 365 on President's Rule, and the importance of 366 and 367 for definitions and interpretation. Don't underestimate this part. A question from here can be a rank deciding one. That's all for today's session. I hope this detailed breakdown of Part 19 was helpful. If you have any doubts, feel free to drop them in the comments below. We love hearing from you. If you found this video useful, please hit the like button, share it with your fellow aspirants, and don't forget to subscribe for more deep dives into the Indian Constitution. Keep studying, stay consistent, and we'll see you in the next video. Thank you for watching.